Of the committee, thank you for including me in today's hearing. I'm honored to be here representing the people of the FBI. I hope we have shown you through our actions and our words how much we at the FBI value your oversight of our work and how much we respect your responsibility to investigate those things that are important to the American people. Thank you for showing that both are being taken very seriously. As you know, our practice is not to confirm the existence of ongoing investigations, especially those investigations that involve classified matters. But in unusual circumstances, where it is in the public interest, it may be appropriate to do so, as Justice Department policies recognize. This is one of those circumstances. I have been authorized by the Department of Justice to confirm that the FBI, as part of our counterintelligence mission, is investigating the Russian government's efforts to interfere in the 2016 presidential election. And that includes investigating the nature of any links between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. As with any counterintelligence investigation, this will also include an assessment of whether any crimes were committed. Because it is an open, ongoing investigation and is classified, I cannot say more about what we are doing and whose conduct we are examining. At the request of congressional leaders, we have taken the extraordinary step, in coordination with the Department of Justice, of briefing this Congress's leaders, including the leaders of this committee, in a classified setting in detail about the investigation. But I can't go into those details here. I know that is extremely frustrating to some folks, but it is the way it has to be, for reasons that I hope you and the American people can understand. The FBI is very careful in how we handle information about our cases and about the people we are investigating. We are also very careful about the way we handle information that may be of interest to our foreign adversaries. Both of those interests are at issue in a counterintelligence investigation. Please don't draw any conclusions from the fact that I may not be able to comment on certain topics. I know speculating is part of human nature, but it really isn't fair to draw conclusions simply because I say that I can't comment. Now, some folks may want to make comparisons to past instances where the Department of Justice and the FBI have spoken about the details of some investigations. But please keep in mind that those involve the details of completed investigations. Our ability to share details with the Congress and the American people is limited when those investigations are still open, which I hope makes sense. We need to protect people's privacy. We need to make sure we don't give other people clues as to where we're going. We need to make sure that we don't give information to our foreign adversaries about what we know or don't know. We just cannot do our work well or fairly if we start talking about it while we're doing it. So we will try very, very hard to avoid that, as we always do. This work is very complex, and there is no way for me to give you a timetable as to when it will be done. We approach this work in an open-minded, independent way, and our expert investigators will conclude that work as quickly as they can, but they will always do it well, no matter how long that takes. I can promise you we will follow the facts wherever they lead. And I want to underscore something my friend Mike Rogers said. Leaks of classified information are serious, serious federal crimes for a reason. They should be investigated and, where possible, prosecuted in a way that reflects that seriousness so that people understand it simply cannot be tolerated. And I look forward to taking your questions.
Thank you, Director Comey. Admiral Rogers, I first want to go to you. On January 6th, 2017, the intelligence community assessment assessing Russian activities and intentions in recent U.S. elections stated that the types of systems Russian actors targeted or compromised were not involved in vote tallying. So my question as of today, Admiral Rogers, do you have any evidence that Russia's cyber actors changed vote tallies in the state of Michigan?
No, I do not, but I would highlight we're a foreign intelligence organization, not a domestic intelligence organization. So it would be fair to say we are probably not the best organization to provide a more complete answer.
How about the state of Pennsylvania?
No, sir.
The state of Wisconsin?
No, sir.
State of Florida?
No, sir.
The state of North Carolina?
No, sir.
The state of Ohio?
No, sir.
So you have no intelligence that suggests or evidence that suggests any votes were changed?
I have nothing generated by the National Security Agency, sir.
Director Comey, do you have any evidence at the FBI that any votes were changed in the states that I mentioned to Admiral Rogers?
No.
Thank you. Admiral Rogers, I know that there was a leak of information regarding Director Clapper and former Secretary of Defense Carter were looking at relieving you of your duty. Are you aware of those stories?
I'm aware of media reporting to that.
And those stories were leaked as soon as you had visited with President-elect Trump. Is that correct?
Yes, sir. I was asked if I would be prepared to interview with the Trump administration for a position, which I did.
Did the leak of that information at all impact your ability and your assessment that you did for the intelligence community's assessment on January 6th?
No, sir. If I spent time in this job worrying about unsourced media reporting, I'd never get any work done.
Thank you, Admiral. Director Comey, I remain extremely concerned about the widespread illegal leaks that you just referenced in your testimony. Just for the record, though, I want to get this on the record. Does the unauthorized disclosure of classified information to the press violate 18 U.S.C. 793, a section of the Espionage Act that criminalizes improperly accessing, handling, or transmitting national defense information?
Yes.
Would an unauthorized disclosure of FISA-derived information to the press violate 18 U.S.C. 798, a section of the Espionage Act that criminalizes disclosure of information concerning the communication and intelligence activities of the United States?
Yes, in addition to being a breach of our trust with the FISA court that oversees our use of those authorities.
Thank you, Director. At this time, I'm going to yield to Mr. Roney, who chairs our NSA Cyber Committee, for questions.
Thank you, Mr. Chairman. I'd like to direct my questions first and foremost to Admiral Rogers to convey my thanks to the many men and women for their dedication at the NSA for keeping our country safe, as well as I want to talk about the recent media stories that may have led to confusion in the public about what the NSA is and is not legally collecting and the safeguards the NSA has put into place to protect personal data. So I'd like to clarify, as the chairman of the subcommittee on the NSA, I recently got to meet your deputy admiral last week out at the NSA, and we visited and spoke some of these things. And what we can talk about here today publicly, if you could go into, if you can't, you can't. But I think that this is important for the people in the room and listening outside understand. Is it true that the NSA would need a court order based on probable cause to conduct electronic surveillance on a U.S. person inside the United States?
Yes, sir.
And just to be clear, the section of the FISA that is expiring later this year, that's 702, which we'll be talking about a little bit, cannot be used to target U.S. persons or persons in the United States. Is that correct?
Yes, sir.
Section 702 focuses on non-U.S. persons outside the United States primarily, correct?
Yes, sir.
Do you believe that the Section 702 is important and valuable for U.S. national security?
Yes, sir.
So it's safe to say that without having this tool, it would be a threat to our national security.
It would significantly impact my ability to generate the insights that I believe this nation needs.
In the media, there's a lot of reporting about something called incidental collection. Can you talk about what incidental collection is?
Yes, sir. Incidental collection is when we are targeting a valid foreign target, for example, and in the course of that targeting, we either get a reference to a U.S. person or suddenly a U.S. person appears as part of the conversation. That's what we call incidental collecting.
And what do you do when something like that happens? If there's a U.S. person part of an incidental collection, what kind of safeguards are put in place to make sure that?
So it depends specifically on the legal authority that we're using to execute the collection in the first place, but in broad terms, realizing again, it varies a little bit by the specific authority that we're using to conduct the collection. We step back and we ask ourselves first, are we dealing with a U.S. person here? Is there something that we didn't expect to encounter that we've now encountered? We'll ask ourselves what leads us to believe that it is a U.S. person. If we come to the conclusion that it is a U.S. person, then we ask ourselves, are we listening to criminal activity? Are we seeing something of imminent threat or danger, for example? Or are we just receiving something that has nothing to do with any of our valid collection authority? Based on that, we'll then take a series of actions. In some case, we will just purge the collect. Make no reporting on it, not retain the data. It's incidental collection. It has no intelligence value, and it wasn't the purpose of what we were doing. In some cases, then, if we believe that there is intelligence value, for example, whether it's a reference to a U.S. person, as an example in a scenario, in our reporting, then we will mask the identity of the individual. We'll use a phrase like U.S. person 1 or U.S. person 2. And I would remind everyone that for our purposes, U.S. person is defined very broadly. That is not just a U.S. citizen. That is a U.S. corporation. That is a ship or aircraft that is registered in the United States. That is an internet protocol address, for example. So it's not just a particular individual, if that makes sense. The term for us is much broader because it's designed to ensure our protections of U.S. persons.
And those, the procedures and protections you talked about are required and approved by the FISA court, is that correct?
Yes, sir, and the Attorney General.
And you mentioned in your opening statement that for that kind of information to be disseminated outside of your agency in the NSA, that dissemination would be strictly on a need-to-know basis. Is that correct?
We use two criteria. Is there a need to know in the course of the person or group that is asking for the identification? Is there a valid need to know in the course of the execution of their official duties?
So, who would that be?
It could be another element with the intelligence community. It could be another element within NSA. It could be a military customer, for example, who's reading some of our reporting. It could be a policymaker. I apologize. There was one other point that I wanted to make, but I've lost the thread in my mind. I apologize if I jump in a moment. I'll try to make it.
Let's get back to masking briefly. You spoke about masking and trying to keep a U.S. Person's identity concealed. And when it is disseminated, we often talk about in the intelligence community about the exceptions to if somebody's masks, how you unmask them. What would the exceptions to that masking be before it's disseminated?
So again, we use two criteria: the need to know on the person requesting us and the execution of their official duties, and the second part was, is the identification necessary to truly understand the context and the intelligence value that the report is designed to generate? Those are the two criteria we use.
Is that identity of a U.S. person communicating with a foreign target, is that ordinarily disseminated in a masked or unmasked form?
No, it is normally disseminated. If we make the decision that there's intelligence value and we're going to report on it, it is normally disseminated in a masked form. I would, again, as I said, we'll use a reference, U.S. person 1, U.S. person 2. I would highlight, if you look at the total breadth of our reporting involving U.S. persons at all is an incredibly small subset, in my experience, of our total reporting.
Who normally in the NSA would make the decision to unmask?
There are 20 individuals, including myself, who I have delegated this authority to approve unmasked requests.
And does the level of approval change depending on the reason for unmasking? If it was something or somebody, say, really important, would that matter, or could it be?
It's not necessarily designated in writing that way, certainly by custom and tradition. At times, requests will be pushed up to on the senior most of the 20 individuals. Requests will be pushed to my level saying, hey, sir, we just want to make sure that you're comfortable with this.
So 20 people, what procedures or safeguards are put in place to make sure that those 20 people are not unmasking, wrongly?
So they retrieve specific training. There are specific controls put in place in terms of our ability to disseminate information out of the databases associated with U.S. persons.
Okay, let's run through the exceptions quickly through a following hypothetical. If the NSA collects a communication where a target under surveillance is talking to a U.S. person, how would the NSA determine whether disseminating the U.S. person information is necessary to understanding the foreign intelligence or assess its importance?
So first, we'll try to understand the nature of the conversation. Is this truly something that involves intelligence or a national security implication for the United States, or is this just very normal, reasonable conversations, in which case we have no desire to have any awareness of it? It's not applicable to our mission. And I said in that case, normally we'll purge the data. We'll ask ourselves, is there criminal activity involved? Is there potential threat or harm to U.S. individuals being discussed in the conversation, for example?
If there was criminal activity involved, what would you do then?
If we decide if it's criminal activity, we'll disseminate the information. If the FBI or other criminal activities are on the reporting stream, in some cases, I also will generate a signed letter under my signature in specific cases to Department of Justice, highlighting that what we think we have is potential criminal activity, but because we are not a law enforcement or justice organization, we're not in a place to make that determination.
Okay, based on that, again, hypothetically, if the NSA obtained the communication of General Flynn while he was communicating with a surveillance target legally, would you please explain how General Flynn's identity could be unmasked based on the exceptions that we discussed?
Sir, I'm not going to discuss even hypotheticals about individuals. I'm sorry.
If I could make reference to a Washington Post article that I have here from February 9th, which states, let me say what it is and I'll ask if you've read it or if you've seen it, which states national security under Michael Flynn privately discussed U.S. sanctions against Russia with the country's ambassador to the United States during the month before President Trump took office, contrary to public assertions by Trump officials, current and former U.S. officials said. The article goes on to say that 9 current or former officials who were in senior positions at multiple agencies at the time of the call spoke under the condition of anonymity to discuss intelligence matters. Did you read this article?
I apologize, sir. It's not an article that references 9 particular individuals. It doesn't necessarily ring a bell. I've certainly seen plenty of media reporting to that, but again, I'm not going to comment on specifics.
Just basically, under the breadth of that article, when we hear that 9 former current officials had spoken to the press under the condition of anonymity, and we heard Director Comey and the chairman speak of this as a potential crime, a serious crime under the Espionage Act. Assuming if this article is accurate, who would be in a position to request the unmasking of General Flynn's identity? Would that be you?
I would have the authority to do that.
Who else would?
The 19 other individuals.
Would that include Director Comey?
I'm talking about
in the
20
NSA
individuals
alone.
Within the National Security Agency, and we're talking about NSA reporting.
But would people like Director Comey also be able to request that?
Yes.
And the Attorney General and Director Clapper, are those type of people also on this list?
Again, I'm not going to talk. In general, yes, they would be
Generally
able to come
speaking,
and ask.
not with regard
They would be able to come and ask. Not going to talk about the specifics of an individual or hypothetical scenarios.
Well, here's what I'm trying to get at. If what we're talking about is a serious crime, as has been alleged, in your opinion, would leaking of a U.S. person who has been unmasked and disseminated by intelligence community officials, would that leaking to the press hurt or help our ability to conduct national security matters? Okay, if it hurts, so this leak, which through the 702 tool, which we all agree is vital, or you and I at least agree to that, do you think that leak actually threatens our national security? If it's a crime, and if it's unveiling a masked person And this tool is so important that it could potentially jeopardize this tool when we have to try to reauthorize it in a few months. If this is used against the ability of us to reauthorize this tool, and we can't get it done because whoever did this leak, or these 9 people that did this leak, create such a stir, whether it be, in our legislative process or whatever, that they don't feel confident that a U.S. person under the 702 program can be masked successfully and not leak to the press. Doesn't that leak hurt our national security?
Yes, sir.
Can you think of any reason why somebody would want to leak the identity of a masked person?
No, sir. I have raised this directly with my own workforce over the course of the last few months to remind everyone part of the ethics of our profession, not just the legal requirement, but the ethics of our profession as intelligence professionals, is we do not engage in this activity. And I've also reminded the men and women of the National Security Agency, if I become aware of any such conduct, there is no place for you on this team. It's unacceptable to citizens of the nation.
Well, I think that,
anyone would engage in this.
as we move forward, obviously, I think that what you're speaking of is this sacred trust that the intelligence community has with the American people and with the people that are representing them here on this dais. And I think that it's vital that for those who break that sacred trust, if they are not held accountable, whether it by the NSA internally or by the FBI through conviction or investigation / prosecution and / conviction through the Attorney General's office of that crime, it is very difficult for us to be able to keep that sacred trust, to know that what we're doing is valid and what we're doing has no nefarious motivations, and to us to be able to keep America safe without violating the constitutional protections that we all enjoy. Mr. Chairman, I'm not sure how much more time I have left. I just wanted to
Congressman, can I make one comment if I could? I apologize. It comes to mind based on your question. I just want to remind everyone that in general, FISA collection on targets in the United States has nothing to do with 702. I just want to make sure we're not confusing the two things here. 702 is collection overseas against non-U.S. persons.
Right, and what we're talking about here is, incidentally, if a U.S. person is talking to a foreign person that we're listening to, whether or not that person is unmasked.
I just want to make sure we understand the context, that's all.
And whether or not somebody in the intelligence community that we put the trust in is going to leak that information to the press for whatever reason. And I'm not even going to get into the gratuitous, what that reason may be. But it's really going to hurt the people on this committee and you all in the intelligence community when we try to retain this tool this year and trying to convince some of our colleagues that this is really important for national security. When somebody in the intelligence community says, you know what, the hell with it. I'm going to release this person's name because I'm going to get something out of it. We're all going to be hurt by that if we can't reauthorize this tool. Do you agree with that?
Yes, sir.
Mr. Chairman, do I have enough time to talk about the letter that the committee sent? The committee sent to you on March 15th a letter to Admiral Rogers and to Director Comey. Have you had a chance to look at this letter? I think that you've actually...
Yes, sir. In fact, I've given you a reply on the 17th.
Just real quickly, because I don't want to take up any more time, can you give us a sense of how many unmasked U.S. persons' identities were disseminated by the NSA from June 2016 to June 2017?
No, sir. As I have indicated, we're in the process of compiling that information. I will provide it to the committee, but until that work is done, I am not going to comment.
Can you tell us whether any of those disseminations broadly involved U.S. people relating to presidential candidates Donald J. Trump or Hillary Clinton and their associates in 2016?
I won't answer until I complete the research, sir.
Assuming that the NSA disseminated unmasked U.S. persons' information relating to the Trump or Clinton campaigns, would that have been a reason for such unmasking?
I apologize. I don't truly understand the question.
Let me just move on to the next one. Along those lines, if the NSA had wanted to disseminate unmasked U.S. persons' information related to either the presidential campaign, who in the NSA would have approved such disseminations?
Again, it would have been one of the 20, and I provided that in my initial response to the committee. I've outlined the procedures. I've outlined the specific 20 individuals.
Thank you, Admiral. I appreciate your answers. I look forward to working with you on the subcommittee moving forward. And, Mr. Chairman, I yield back.
Gentleman yields back. Mr. Gowdy is recognized.
Thank you, Mr. Chairman. Director Comey, we will begin this line of questioning, then we'll finish it the next round. FISA and other similar related counterterrorism programs have been described even this morning as vital, critical, and indispensable to our national security. And many of us on both sides of the aisle believe FISA and similar counterterrorism programs prevent terrorist attacks and save American lives. But FISA and other surveillance programs are intentionally designed to preserve the privacy of U.S. citizens. They are intentionally designed to ensure the information is collected and used only for legitimate national security and criminal investigative purposes. There are statutory safeguards. There are warrants based on probable cause. There is a FISA court that is involved. There are audits on the back end, and we think so highly of this material. It is a felony punishable by up to 10 years in federal prison to unlawfully disseminate it. All of this was done to make sure this information gathered remains protected as it relates to U.S. citizens. The way I view it, Director Comey, the American people have an agreement with their government. We are going to give you the tools to keep us safe, even if it infringes on our privacy some. We're going to give you the tools. And government in return promises to safeguard the privacy of U.S. citizens. And when that deal is broken, it jeopardizes American trust in these surveillance programs. So let me ask you, do you agree FISA is critical to our national security?
I do.
Do you agree programs like FISA were intentionally designed to safeguard the identity of U.S. persons?
Yes, there are other important elements of it, but that's the primary goal, I believe.
It wasn't an afterthought. It wasn't an accident. These are intentional safeguards that we put in place to protect U.S. citizens. Is that correct?
Correct.
Do you agree much of what is learned from these programs is classified or otherwise legally protected?
All FISA applications, review by the court, collection by us pursuant to our FISA authority is classified.
The dissemination of which is a felony punishable by up to 10 years in prison?
Sure, dissemination, unauthorized dissemination.
Unauthorized dissemination of classified or otherwise legally protected material punishable by a felony up to 10 years in federal prison.
Yep, yes, as it should be.
All right. In January of this year, the Washington Post reported, according to a senior U.S. government official, a named U.S. citizen, and I will not use the name, a named U.S. citizen, phoned the Russian ambassador several times on December the 29th. In February of this year, the Washington Post reported nine current and former officials who were in senior positions at multiple agencies at the time of the call spoke on the condition of anonymity to discuss intelligence matters, and that officials began poring over intelligence reports, intercepted communications, and diplomatic cables. In February of this year, the New York Times reported a U.S. citizen, whose name I will not use, discusses sanctions with the Russian ambassador in a phone call, according to officials who have seen a transcript of the wire-tapped conversation. And again in February of this year, the New York Times reported on a phone call involving a U.S. citizen, including significant discussions of phone records, intercepted calls, intercepted communications, and reported the NSA captured calls and then asked the FBI to collect as much information as possible. My time is up, so I will say this for this round. I thought it was against the law to disseminate classified information. Is it?
Oh, yes, sure, it's a serious crime. I'm not going to comment on those particular articles because I don't want to, in any circumstance, compound a criminal act by confirming that it was classified information. But in general, yes, it's a serious crime, and it should be, for the reasons you said.
We'll take it back up next round, Mr. Chairman.
Gentleman yields back. I'll now yield 15 minutes to Mr. Schiff.
Director Comey, I want to begin by attempting to put to rest several claims made by the President about his predecessor, namely that President Obama wiretapped his phones. So that we can be precise, I want to refer you to exactly what the President said and ask you whether there is any truth to it. First, the President claimed, quote, "Terrible. Just found out that Obama had my wires tapped in Trump Tower just before the victory. Nothing found. This is McCarthyism," unquote. Director Comey, was the President's statement that Obama had his wires tapped in Trump Tower a true statement?
With respect to the President's tweets about alleged wiretapping directed at him by the prior administration, I have no information that supports those tweets, and we have looked carefully inside the FBI. The Department of Justice has asked me to share with you that the answer is the same for the Department of Justice and all its components. The Department has no information that supports those tweets.
The President accused Mr. Obama and presumably the FBI of engaging in McCarthyism. As you understand the term McCarthyism, do you think President Obama or the FBI was engaged in such conduct?
I'm not going to try and characterize the tweets themselves. All I can tell you is we have no information that supports them.
Were you engaged in McCarthyism, Director Comey?
Try very hard not to engage in any isms of any kind, including McCarthyism.
The President second stated, quote, "Is it legal for a sitting president to be wiretapping a race for president prior to an election? Turned down by a court earlier, a new low," unquote. Director Comey, can you answer the President's question? Would it be legal for President Obama to have ordered a wiretap of Donald Trump?
I'm not going to characterize or respond to the tweets themselves. I can tell you in general, as Admiral Rogers and I were just saying, there is a statutory framework in the United States under which courts grant permission for electronic surveillance, either in a criminal case or a national security case, based on a showing of probable cause, carefully overseen. It's a rigorous process that involves all three branches of government, and it's one we've lived with since the late 1970s. That's how it works. So no individual in the United States can direct electronic surveillance of anyone. It has to go through an application process, ask a judge. The judge can then make the order.
So President Obama could not unilaterally order a wiretap of anyone?
No president could.
Mr. Trump also asserted in that tweet that that the application or the President's order was turned down by a court. Was there any request made by the FBI or Justice Department to wiretap Donald Trump turned down by a court?
That's one of those subjects I can't comment on one way or another. Please don't interpret that in any way other than I just can't talk about anything that relates to the FISA process in an open setting.
Third, the President stated, "I'd bet a good lawyer could make a great case out of the fact that President Obama was tapping my phones in October just prior to the election." Director Comey, you're a good lawyer. Can you make out a great case that President Obama wiretapped Mr. Trump's phones just prior to the election, in light of the fact you have said there's no evidence of that?
All I can say is what I said before, that we don't have any information that supports those tweets.
Well, in my view, then, you would not be a great but a very unethical lawyer to make out such a case. And finally, the President made the following accusation: "How low has President Obama gone to tap my phones during the very sacred election process? This is Nixon, Watergate, bad or sick guy." Director Comey, the President has compared Mr. Obama to Nixon and purported wiretap of Trump phones as another Watergate. What was the gravamen of the offense by Nixon and his operatives during Watergate? A lot of people who may be watching may be too young to understand what Watergate was about. What was the gravamen of that offense?
Well, as I recall it, and I was a kid, but have studied it quite a bit in school, the gravamen of it was an abuse of power, including break-ins, unlawful wiretaps, obstruction of justice, sort of the cycle of criminal conduct.
And it was a break-in of the Democratic headquarters by operatives of the president, was it not?
That's my understanding is that's how it began. The
And it
investigation
also
began.
involved a cover-up by the president.
Yes, as I said.
Now here, I think you've said there's been no evidence of an illegal wiretap by President Obama. Is that right?
I've said the FBI and the Department of Justice have no information to support those tweets.
But there is evidence, is there not, of a break-in of the Democratic headquarters by a foreign power using cyber means.
Yes, there was. As the intelligence community report, the unclassed report said in January, the Russian intelligence services hacked into a number of enterprises in the United States, including the Democratic National Committee.
And there was an effort by the Russians to cover up their break-in of the Democratic Party headquarters by using cutouts like WikiLeaks to publish the stolen material. Isn't that right?
Certainly to cover up that they were the ones releasing it.
Director Rogers, in an effort to explain why there was no evidence supporting the president's claim that Obama had wiretapped him, the president and his spokesman, Sean Spicer, have suggested that British intelligence, through its NSA or GCHQ, wiretapped Mr. Trump on President Obama's behalf. Did you ever request that your counterparts in GCHQ should wiretap Mr. Trump on behalf of President Obama?
No, sir, nor would I. That would be expressly against the construct of the Five Eyes agreement that's been in place for decades.
And the Five Eyes are some of our closest intelligence partners, and Britain is one of them.
Yes, sir.
Have you seen any evidence that anyone else in the Obama administration made such a request?
No, sir, and again, my view is the same as Director Comey. I've seen nothing on the NSA side that we engaged in any such activity, nor that anyone ever asked us to engage in such activity.
And if you were to ask the British to spy on America, that would be a violation of U.S. law, would it not?
Yes, sir.
Our relationship with British intelligence is one of the closest we have with any foreign services. Isn't that true?
Yes, sir.
Now, our British allies have called the president's suggestion that they wiretapped him for Obama nonsense and utterly ridiculous. Would you agree?
Yes, sir.
Does it do damage to our relationship with one of our closest intelligence partners for the president to make a baseless claim that the British participated in a conspiracy against him?
I think it clearly frustrates a key ally of ours.
Certainly wouldn't endear the British intelligence services to continue working with us, would it?
I believe that the relationship is strong enough. This is something we'll be able to deal with.
But it's not helpful. You
Yes,
would
sir.
agree. Director Rogers, President Trump recently met with German Chancellor Angela Merkel. During a joint press conference, the president suggested that they both had something in common, that they had both been wiretapped by President Obama. Director Comey has just demonstrated why the claims by the president about his being wiretapped by Obama were unsupported by any evidence. But the claim he made about wiretapping directed at Merkel referred to something that came up in the context of the Snowden disclosures. I'm not going to ask you to comment on whether the chancellor was the subject of any eavesdropping, but I would like to ask you whether the Snowden disclosures did damage to our relationship with our German ally, and whether the chancellor herself expressed her concern at the time.
Yes, sir.
In light of this, is it helpful to our relationship with the chancellor or our relationship with German intelligence to bring this up again in a public forum?
It certainly complicates things, but again, I'd like to think that our relationship is such we're going to be able to deal and keep moving forward.
So our relationships with the British and the Germans, you hope, are strong enough to withstand any damage done by these comments?
By anything in general, sir. We have foundational interests with each other. We need to keep working together.
This time, Director Comey, let me ask you a few questions you may or may not be able to answer. Do you know who Roger Stone is?